Okay. Hi everyone, welcome. We will start today right on time. So there are two more, we'll wait for 2 more minutes, wait for more people to come in and then we will start it right at 5 PST. All right, right on time. So we'll get started. Welcome, everyone. Thank you so much for joining us today. There were a lot of going on past couple weeks. So we're going to take this chance to give you guys some informations, some insights from today's speakers. We did invite Meng Xiaojie from the her law group, and then she'll give you a more professional explanation of what's going on with this new DHS F-1 rules. And then, of course, she'll also touch on the new H-1B rules from President Trump pretty recently. And for people who are not familiar with Go Elite, I'll give you a very brief introduction of us. We are an education agency located in LA area. We have our office in Pasadena. We are ARIC accredited. This is the high accreditations in the United States for education industry. And we do help giving you more information about the hybrid professional programs, F1 reinstatement, emergency transfer, and change of status support. If you do wanted to know more information later on, feel free to sign up and then join the list. We will update you whether there will be new webinars going on in the future and stay tuned to our events. We also on Google, so many of students submit their Google reviews. We get plenty of 5-star reviews. Students are very satisfied with our consultant service. We also on all different type of social platforms, posting informations or about the school, about the policies. So feel free to subscribe to any of those platforms. I do see there is students raise your hand. We are not going to answer any questions live. So if you have any questions, we will be able to answer your questions in the later on Q&A section. So please submit your question into the QA only, okay? If you drop in the chat box, it's very possible that we will miss your question. So please drop them into a QA. We'll later on address those questions. We have a lot of people attending to this webinar. I'm sure that you guys all have so many questions about those new rules. If we didn't get to answer every questions, feel free to reach out to Meng Xiaojie or feel free to reach out Go Elite. We will be able to answer them later on. All right, I will stop sharing and then I will hand it to you. Okay, there we go.
All right. Thank you very much, Vivian. Thank you for organizing this very timely webinar. I know the initial topic of today's webinar is about the proposed F1 rule, the rule about shortening the time, or not shortening, but imposing a fixed period to the F1 status. But as we all know, a lot of things have happened one after another since last Friday. So I will also explain what happened during last Friday, and also some of the government clarification on Saturday, including yesterday from DOS. And also we know today there is this proposed rule on the weighted selection for H-1B expected to start next year. We don't know if it's really going to start, due to maybe some lawsuit or anything, but we're going to discuss like what it looks like and how it may impact some of you. Okay, so we're going to start. Because there's a lot to be covered. It may not be very, very detailed, but I hope it will have, help you understand like what are the main, like the key points from each rules. And also the most important thing is to also understand the like what's the status of those rules because they are all staying at different stages. Like say the F-1 rule, like we have this one rule on the F-1 proposed rule. So it's currently in the public comment period, and the period will end September the 29th. So it's still within the public comment period. So that means all of you can leave comment. And when the government finalizes the rule, the government is going to consider each comment and they're supposed to reply to each one of them. So I would encourage all of you to leave your comment during this public comment period. And the next rule about the president proclamation, it's good that the government agencies all came out and provide some clarifications. But I would have to say some parts I don't think is as clear as we'd like. So I'm going to point out which parts are not so clear, which might have triggered, so much confusion still overall, like especially for those who are going to participate in next year's lottery. And for the weighted H-1B lottery rule that come out today, it's going to be officially published to the Federal Register tomorrow. And there will also be a 30-day public comment period. So this is also not finalized. It will start the public comment period tomorrow. So you guys are all also very welcome to leave comments to this rule. So we will see the president proclamation was like in effect yet, not yesterday, but on Sunday, September the 21st. But the other two rules, they are not finalized. From our past experience, usually the final rule would look quite different from the proposed rule, depending on how the government is receptive, whether the government is receptive to a lot of the comments and how much change it's gonna make in the final rule. So the comments are really important to the final rule, what the final rule looks like. Okay. First of all, very important, this is for general education purpose. It's not intended as legal advice, especially I'm gonna share some maybe chart here and there. When you are making, especially like travel plans, please do consult your own attorney before you make any travel plans. Either that's leaving the US or coming into the US, please consult your attorney because this is for general purpose and it doesn't consider your personal immigration history. And also a lot of things are still developing. And also something that may be valid today, may change over the time due to some new policies, new rules. So make sure you always consult your attorney before you make those plans. And also, please do not share the information without the consent from me and Go Elite because, again, just to avoid any potential misleading information without a context. You are free to take notes for your own, study, but please do not share any of the screenshots or any part of the video to any social media because, those can maybe create some confusion without context. Okay, thank you. And a little about myself, I have started practicing law since 2012. So I also practiced immigration law during the first Trump administration. So a lot of things we are experiencing today are very similar to what happened during the first President Trump's first administration. So I deal with most of the work visas and employment-based cases, and also student status cases. So that's my specialty. Feel free to ask any questions you may have. Okay, without further ado, we're going to start our workshop today. So I'm going to start from the latest news, the H-1B lottery. Okay, so that's more straightforward than the president's proclamation last Friday. That's more straightforward. But again, this is not the final rule yet. That's still a proposed rule. It may still change if, depending on what kind of comments the government receives and how receptive it is to those comments, and also whether there might be litigation. I'm pretty sure there will be lawsuits on this one. And also it depends on how the court rules on the case. So this is what today's news. It is about some change to the H-1B lottery, okay? Basically, we know the lottery currently is a random lottery, right? Everybody gets one chance in the lottery. For some with US advanced degrees, you're gonna have another chance in the 20,000 master cap. That's some extra. But basically, within the 65,000 regular cap, it's purely random. It has nothing to do with any other factors except your luck. Same thing within that 20,000 advanced degree cap. Nothing else except your luck for all those who hold US advanced degree. So that's how the lottery is conducted right now. So in this proposed rule, another factor will be one factor will be very important. It's no longer so random, and that factor is the H-1B wage level. So for those of you who may know H-1B a little bit, I'm not gonna explain that too detailed, just give you some idea. For each H-1B petition, you have to indicate what is the SOC code for this position, right? Because we have to classify it. So it depends on what kind of job you do. It can be software developer, it can be accountant. So you need to classify it. What is the SOC code? And then there's also the work location, because at different location, the wage level is different. And then for each employer, depending on the employer's requirement for the position, you may have different levels, like within this code in this area. And there are 4 levels. So for all the positions, you're gonna fall within those 4 levels. Level 1 is the lowest level. Level 4 is the highest level, depending on how much you're paid and then what the company's requirement is for the position. So right now, level 4, people whose wage level is at the level 4 would get 4 chances, like 4 times. They're gonna be entered into the pool 4 times. Level 3, they're gonna enter into the pool 3 times. Level 2, they're gonna enter into the pool twice. Level 1, still once. So you can see, that's different, okay? So what does that mean? It really depends on, first, how many registrations there will be next year. And 2, depending on how many registrations there will be for each level. So here is a table published by, sorry, it's not play mode. This is a table published by the government when they are publishing this proposed rule. This is how many registrations they received for different levels. Let's just assume the number of registration remain the same next year, because next year it may be different. Maybe because of this new rule, more people are in maybe the level 3 or level 4 category. It's possible too, but let's just assume nothing's gonna change. So currently we can tell for each group, they are gonna have like a 30% chance of getting selected. But with this weighted selection process, we can tell if you're at level 2, your chance is gonna remain the same. However, if you're in the level 1 category, your chance will be half, okay? It used to be 30%, but now it's gonna be 15%. But for people at the level 3, it's going to be 46%. And for level 4, that's going to be 61%. And that's doubling level 2, and that's 4 times level 1. So that's just a comparison of how that's going to affect people at different wage levels. So that's something proposed by the USCIS, like by the DHS today, you guys can still, to make comments. Like practically speaking, like when it comes to the actual registration, that means besides what you have already provided right now, you also will need to have like the SOC code ready, work location ready, and the wage level ready at the time of registration. So that's going to be something different from the current registration process. And also the government has already anticipated some ways maybe to kind of like game the system, like, maybe some employers would put someone to a rural area, right? So that the same amount of wage would hit like level 4. And then after case approved, they're going to move this person to another place and lower the wage level. That's going to be considered fraud, okay? And then that's going to be revoked if it's caught. And maybe denied, if amendment is filed. So the government did look into some of the possible ways that the system might be misused, might be abused. That's what it is like right now. Okay, so that's the latest news today. And the next is also the most important of the most confusing. That's the president proclamation announced last Friday. As we all know, it caused a lot of chaos, especially for those who happen to be outside the US on Friday. A lot of H-1B employees had to rush back to the US on Saturday so that they won't be affected by this H-1B travel ban, which was initially supposed to apply to them and take effect from Sunday. This is what it looks like, okay? It restricts the entry, that's the first section, section 1, it restrict the entry of H-1B workers, and then unless that's accompanied or supplemented by a payment of 100K. Like how to make the payment of 100K, even the employer is willing to, we don't know yet. There's no payment link yet, but it was released and it took effect from Sunday. The part that caused confusion, I think, is the timing of the payment. I will explain later why this is causing a lot of confusion right now. Because the government wasn't too clear about when the employer is supposed to make that payment. From all these government clarification, my read is going forward, USCIS is going to take that money. So the payment is supposed to be made at the time of filing the petition. It's not after you have the petition filed and then apply for the visa. It looks like the DHS would require that amount at the time of the petition filing. Okay, but it didn't make it that clear when it was initially released. So that was causing a lot of confusion. Second, the DHS, the Homeland Security, should restrict decisions on position. So that's talking to USCIS, right? For those who are currently outside the US. Currently means when this proclamation was published. That was September the 19th. So for those who were outside the US at the time, then any petition filed for them would require the payment. That's first of all, this is what the policy looked like September the 19th, Friday, when it was initially released. That was why it was causing a lot of chaos, because it's going to affect pretty much everyone who was outside the US at that moment, including those who were having a valid visa, and also including those who were waiting for a petition to be approved and who happened to be outside the US at that moment. It didn't involve an annual fee. So annual fee was a rumor that came from some of maybe the news before this proclamation was released. So when the proclamation was actually released, it didn't mention any annual fee. And it was more targeting those who were outside the US at the time, with both the petition adjudication and also the entry restriction. Okay, then comes all the government clarification. Like I'm sure you guys may have follow the news a lot. I was there following the news whole day Saturday, and the government clarifications coming from all directions. On Saturday, one day, there were four government sources providing different kind of clarification. So if we do a comparison, each source said something slightly different. That's also very confusing because it's not like they should have some consensus, but no, every time one source said something, the next time another source from the government said something slightly different. It may look still similar, but for those who are having H-1B status, or those who are about to have H-1B status, it could still make a big difference. It would make a difference whether you can enter or not, or whether the employer would have to pay the 100K or not. So the first response comes from this White House account rapid response. It says it only applies to future applications. So next year's lottery cases. It doesn't affect anyone and also next year's case and who are currently outside the US. So this is the most narrow interpretation, only affecting those who participate in next year's lottery and who are currently outside the US. Nobody else is gonna be affected. So that's one. Another comes from also the White House newsroom. Again, it's confirming there's no annual fee. Those who have valid visa won't be affected. But it applies to new visas, and it will first apply in the next upcoming lottery cycle. So they seem to suggest this is a next year's thing. But that's not what the proclamation said, right? So, and these are just X account posts. For most people, we cannot be so sure this is what the government is gonna implement. We cannot go to the CBP, or we cannot file a petition and just attach those X account posts, right? And then we saw some more official announcement, including USCIS and the CBP, because USCIS is the agency that adjudicates petitions. So what they are telling us matters a lot, right? So they confirm something very important here. They also confirmed only applies prospectively to petitions that have not yet been filed. And most importantly, it confirms this: the proclamation does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date. That is September 21st. Are the beneficiaries of currently approved petitions or are in possession of validly issued H-1B visas. The most important part is the second part. This proclamation does not apply to aliens who have approved petition or who are the beneficiary. First part is as important: beneficiaries of petitions that were filed prior to the effective date. What does that mean? That means all of this year's H-1B cap cases are not affected. That means all of the H-1B transfers and extensions, especially if they are here extending their status or changing status, that's not going to be affected. How do we know? Because if you are transferring your H-1B, you're changing employer, or you're extending your employer, that means you must already have a petition approved, right? Or at least have a petition already filed before September the 21st. So that's why you are exempt from this proclamation. So this USCIS announcement give a lot of people a lot of peace of mind. CBP said the same thing, okay? As long as you are a beneficiary of currently approved petition or petitions filed prior to September the 21st. So the USCIS and CBP said the same thing, but they didn't say clearly that that's gonna only apply to next year's lottery, right? Like say, for example, if there's a cap exempt employer who is petitioning for someone who's currently outside the US, technically, according to these memos, they can still be restricted unless the employer pays the 100K. So that's the confusion. Are those cap exempt employers are going to be restricted? It doesn't seem to make a lot of sense. Why does the government want to target those cap exempt? Usually they are nonprofit agencies, right? But the way the current policy is phrased, it looks like those cap exempt employers are going to be restricted. And then here's the DOS H-1B FAQ. I feel like this one is most confusing. It was released yesterday, Monday. On the face, it looks like pretty much the same, but it's not exact the same because DOS is in charge of something different. It is in charge of giving out visa. Okay, so a big question we've heard a lot from people in the US is, okay, good to know my current H-1B doesn't require extra payment right now, and I can just freely still extend my H-1B or transfer H-1B, like to do the change of employer as I need to. But if I have a new petition approved with USCIS, can I still leave and get a visa overseas? That's the question. Who's in charge of visa? DOS does, Department of State does. So that's why their announcement is very important. But that's also very confusing because it says like the proclamation does not apply to the following people. Apply to any previously issued H-1B visas or any petitions submitted prior to September the 21st, 2025. Well, that's it. And then it does say like it require 100K payment accompany any new H-1B visa petition submitted after September 21st. That includes the 2026 lottery and any other H-1B petition submitted like after September 21st, 2025. That is the confusing part. I'm not sure why DOS does that. If just based on that, it does look like even those who can like file, have the employer file the H-1B petition for them after September 21st, that can be H-1B extension, that can be a change of employer, that can be, next year's H-1B lottery too. But even they can still have the petition approved with USCIS unless they had H-1B visa maybe before. I'm not still even sure what is being excluded there. They might not be able to get a visa abroad. I don't know if that's what the DOS intended for. I don't think that kind of make a lot of sense here, but the way just on the face, it looks like so. So I hope DOS will issue some further clarification down the road because I feel like the position it holds kind of is different from the CBP and the USCIS position, and that is causing confusion. Personally, I hope it's maybe just a mistake or it's some sort of overlook because they issued this announcement in a rush, so they didn't have the time to, just 100% align that with CBP and the USCIS. Or maybe because, the payment will be required at the petition filing time. So that's why DOS is saying, okay, as long as you have a petition approved, then I assume USCIS has already done its job to check the payment and everything. So I don't have to double check it. Maybe that's what it means. But again, this is the ambiguity here. So for those who will have new petitions filed after September the 21st, you will have no problem having the petition approved within the US. But if you want to use that new petition to apply for a visa abroad, I think there's still some uncertainty at risk here because based on the DOS announcement, I don't think that's very clear that you can get a visa and not subject to the 100K payment. Okay, so this is a chart we made. Just want to do a disclaimer again. Please do not rely this on a legal opinion before you leave the US. Please do check with your own attorney. Please do not send to the social media so others may mistakenly take this as legal advice. Please don't do that. But this is a chart we made for you can refer to just as a very general guide of who's affected and who's not. So these are the things you may consider. First, is this person in the US on September the 19th? If the person was in the US on September the 19th, you will see like the petition with USCIS would be no impact. Okay, for sure. There would be no impact if the person is in the US on this date. Something else to consider would be whether the person has a valid H-1B visa at the time, like also like around the effective date. And then there's this question whether the beneficiary has a petition filed for him or her before September the 21st. This is talking about any petition. As long as you ever had a petition filed for you before 2025, September the 21st, then the answer is yes, and then you move on. And then the next question is whether the current petition is filed after September 21st, 2025. If you have another, like a new one, you're going to file. So the difference of this is if this is filed after September the 21st, the answer of impact, the analysis of impact at the visa application stage would be different. So you may see like something that may impact because the DOS announcement wasn't that clear. And then there's this analysis with the entry with CBP. So when you are doing the analysis, you need to do different analysis, whether that's going to be something barred by the USCIS, whether that's going to be something affected, at the visa application stage. Currently, I still kind of analyze them differently just because the language seemed to be different. But they could mean the same thing and they just happen to phrase it differently. So we will still need to monitor this. This is a big source of confusion right now. Okay, so we're coming to the F1 visa status explanation. I'm gonna do a little faster. First, at F1 visa. Visa is the stamp in your passport. This is something that need to be valid at the time of entry. But this is not the proposed rule is regulating. The proposed rule is about the status within the US. So currently, when someone enters on F1 visa, your status would say D/S, duration of status. That means you are gonna be invalid status as long as you're still in your program hasn't ended, your CVIS is still active. So that's how it's currently managed. So losing status doesn't mean like a visa expiration. Okay, even your visa, you can still be in perfect lawful status in the US. Even your visa has expired because you only need a valid visa at the time of entering the US. After the entry, your visa, your F1 visa, is governed by and is managed by the CVIS system, and that's managed by the school DSO. Okay, so the rule is about the status, which means like after you enter the US. So first, current the DHS rule, the proposed rule is gonna put a fixed amount to it. So that's gonna be no more than 4 years plus 30 days for departure. That is very challenging, especially for a lot of PhD students, right? That means you in the middle of your program, like you will have to apply for extension of your status. I would imagine that would be a big inconvenience for most of the PhD students because most of the PhDs cannot graduate within 4 years. So that's a big change. And it's not going to be 4 years for all. It's also going to be the program end date. So for example, you enter with the F1 visa, it's going to end, your status is going to end at your current program end date. If you want to continue studying at another program, you have to file the I-539 application with USCIS with a fee, and you have to wait. So that's extra step. Currently, you just need to contact the school DSO, and DSO is going to do all the changes in the CVIS system, and you don't have to file anything with USCIS. But now you just have to file all these extension of status with USCIS. And some students may consider, oh, that's okay, I can file. I file OPT anyway, right? But it depends. It depends on whether they are going to open premium processing to it, but premium processing would be more cost. And also if they have a lot of application at the same time, you don't know how long it's going to take them to adjudicate it, right? So that's also going to cause a lot of uncertainty. So that's the problem with this rule. Like it kind of like really affects like the students' flexibility to, to finish their program if they're in the PhD program or they change programs. Okay. And then the 60-day grace period is going to be shortened to 30-day. Okay. And while the extension is pending, if you have any kind of employment authorization, let's say for example on-campus employment, if you are working as an RA, TA, your employment authorization is going to still be valid for up to 240 days. Hopefully, most of the application can still be approved within 240 days, but if not, the person would lose the work authorization. That's also going to be some hardship to a lot of people who have on-campus employment. And another biggest change is about your flexibility of to change program or education level. Here in this proposed rule, that's called educational objective. What is educational objective? That is your major and your degree level. So first of all, it doesn't allow graduate level student to change your major or your level within the US at all. No change of program level or major. If you want to change, you have to leave and come back. So that's the rule. Second, it doesn't allow students. So for those who are not within like at the graduate level, you cannot transfer within the first academic year. That's also a hard rule. Those are the things, if you don't like it, you can comment. You can provide a comment. I personally do expect the final rule to relax those a little bit because that seems to be not too reasonable, right? Especially for international students. If they feel like, oh, this program is not the best, the most suitable for me, I want to change to a different program, but I have to be here for at least a full year. I just don't think that is a very reasonable rule to begin with. Anyway, so that's what it says. And then another thing is if you're pursuing your study in the US, you have to move upward, which means after you finish the bachelor, you have to pursue at least master. And after your master degree, you have to pursue doctor degree. If you finish a master degree and then you want to pursue another master degree, sorry, no, that's not allowed. That's what the new rule says. For a lot of you, I know maybe some of you are currently pursuing a second master degree. You're not gonna lose your status immediately, but you most likely, if this is the rule, you won't be able to get into another master degree. You have to move upward. Okay, and then for those who are in language schools, that's capped at 24 months. So one cannot study at the language school for too long, more than 2 years. That's not going to be allowed. Let me see what else. Yeah, and something else is also this is a very harsh. Currently, we know like if for whatever reason you need a little longer to complete your program, you can talk to the school, right? And if the school approves it, then the DSO is going to extend your program end date. So you have a little extra time to complete your program. However, the new rule doesn't allow that either. You cannot extend your program. You just have to complete your program within the originally dedicated time. If you want to extend your program, you have to prove compelling academic, documented, medical, or beyond control circumstance. Those are very hard. For example, disasters, your school closed, that kind of level, extraordinary circumstance. Otherwise, if you are just like, I don't feel like I can keep up with the pace of my program, nope, you still have to complete that within the same time. So that's also very hard. And something else is about extra filing, like say, for example, if one file reinstatement, then that's one thing. And if you have your reinstatement approved and you need extra time to complete the program, again, you have to file an extra application to extend your program end date. Otherwise, you will be considered, losing status again. So that's one. The other is when you are filing, let's say, OPT, you not only have to file your EAD card, you also need to file an extra form, the I-5 39 to extend your F1 status because your status ends at the time of your program end date plus 30 days, right? So in order to have an EAD, you have to extend your status first. So you have to file both. I kind of expect that can cause also a lot of confusion, and some students, if this is the final rule, some students may accidentally fall out of status because they don't know it. It's a little concerning. But that's what the rule is. And, you guys are all very welcome to leave comments so that, hopefully the final rule would be more friendly towards students in the US. Okay, so that's it. Let's take some questions. Okay.
Thank you so much. Okay, we have a lot of questions. In this way, let me share screen. And then before we answer questions, I wanted to let you guys know if we didn't get a chance to answer your question, please feel free to scan the QR code or reach out to Meng Xiaojie, and then she can further explain or give you a solution. And if you have very, very specific questions, we see a lot in the QA, we might not be able to answer them. You might need to reach out later on. Okay, so we'll begin with the very first one. I'm on CPT now, and my employer will be applying H-1B petition on behalf of me next year. In my case, since I'm already in the US now, does my employee needs to pay a 100K fee?
If you are in the US, then anyone who's in the US right now, since September the 19th, your employer won't be required to pay the 100K when they file the petition with USCIS. The only confusion is after the approval of the petition. If you leave to apply for a visa abroad and you've never had H-1B visa before, would this restriction apply? Maybe. That's the part I think not so clear right now. But the petition itself won't require the 100K if you are currently in the US.
Thank you so much. Sorry, just to do a follow-up question on this one specifically. So if they do change their status within the US from, for example, F1 to H1B, they will not need to pay this fee, right?
No, no.
Okay. Thank you for that. All right, the next question is for current student on the one CBT and relying on the DS status, aka visa expired in June 2025, but staying with the US due to the I-20. Okay, what will happen if the new DS rule passes? Will we be allowed to finish our courses, or will we be asked to leave right away?
No, you won't be asked to leave. So there is this grandfather clause. For those who are currently here in the US, you will still be allowed to stay until your current program end date plus the 60-day grace period. So they're still using the original grace period time for those who are in the US.
Thank you so much. My STEM OPT ends at February 2026. Consider a new proposal. Which intake should I join? October end intake or January end intake? I think this question, Go Lee can better answer you. Feel free to scan the QR code. Our consultant can give you a better advice on which intake you need to take, you need to do. Okay. We will skip to the next one. When will the DHS new proposal wage rule for H-1B come into existence if approved?
That's a great question. Yes, it's going to become effective after the rule is finalized and published. It might be challenged in court. I think it's most likely going to be challenged in court. Whether it's going to survive the lawsuit, we don't know yet. We know the lawsuit was kind of like it worked for the applicants last time, but this rule looks different from last rule. So last one wasn't a random selection at all. This one, it's still a random selection, but it has this extra factor. So it's kind of getting really interesting. It depends on how the court looks at it.
Thank you. Next question is day one CBD still legal?
Currently, for those of you who are in your second master program, from this rule, it looks like you can still study until the end of your program. Oh, by the way, a follow-up to this last question, I think that's very important. So the current DHS also kind of expects lawsuits. Also, it kind of expects maybe some technical issues and a complete breakdown of the system. So it says in case the online system doesn't work out, they're gonna revert back to the pre-2020 paper filing lottery. I don't know how many of you are aware of that. But, before we have this online registration system in 2020, the lottery was conducted in a completely different way. So we have to have the full petition like ready by the end of March, and you have to file this within the 5 business days, first 5 business days of April. So that's a paper filing. So you file your petition first, and then USCIS randomly like select from those. So this time DHS says that they're gonna do the same thing, going back to the pre-2020 way, and they're still gonna go by the wage level. Because if you submit a full package, you're gonna have the LCA, all the wage information in it, and they're still gonna do a weighted selection with the paper filing.
All right, thank you so much. That sounds interesting. Okay, so the next question is, I'm currently on F1 STEM OPT and have planned to travel abroad in November and December. Would you advise on travel right now? Is it safe to travel?
It's really a tough question. I can only answer that you are not currently affected by this rule. But I cannot guarantee you there would be no new rule in the future. For example, these H-1B workers who happen to be outside the US on Friday, they didn't know this is coming. Had they known this is coming, they wouldn't have been outside the US, right? But the change happened so quickly, it's overnight, so that's why they had to rush back to the US. So that's the unpredictability right now for a lot of the non-immigrant like workers or students.
Thank you. Can the new H1 be 100K rule be revoked by any chance?
It doesn't seem to be very likely, but there are lawsuits. I know there are lawsuits on the way, because there it can be considered like a violation of the APA Act. So there could be lawsuits. So if the plaintiffs in the lawsuits win the case, then this can fail. But I don't expect the current administration to just voluntarily like revoke it. That's not very likely.
Thank you. And I currently only second master doing my DNCBT and it will end in August 2026. Is it a good idea to transfer to a PhD in October before the new ending DS rule kicks in?
I would say you can still, wait until the final rule comes out. As the proposed rule says, those who are currently in a program can still stay until the end of their program. So you won't lose your status right away.
Thank you for that. For H1B cap extension for nonprofit required to pay 100K annually.
Yeah, the current rule doesn't make a distinction between, nonprofit or for-profit.
Mhm. And I don't think it's annually. I think we have previously explained that's not annually. I currently on my second master doing the activity, and I think that we answered this one. Does this reason rule affect teachers? Also, does this affect those already in the US as student who may need H1B in the future, especially teacher?
If you have been in the US all this time, since September the 19th when the proclamation was issued, your petition would be okay. Whoever petitions for you, whether that's next year's CAP subject or that's a CAP exempt employer, petition won't require the 100K payment. Um, so I hope that answers your question. So at least the petition won't be affected. The only uncertainty is whether the visa is going to be affected. I hope it won't. I don't think it makes sense. Like the government, like DHS doesn't require it, but somehow the DOS says, "Oh, you need to go back and make the payment." I think that's kind of unreasonable. But I just want to play that safe. I just want to caution you. It's not as clear as that like right now in the DOS FAQ.
Thank you. Next one is what advice would you give to someone whose STEM OPT expire in January and are looking into a day one CPT options?
Well, I would say it's really hard because it depends on when this final rule will be released. Because the public comment period ends on September the 29th, depending on how much time the current administration takes to look at all the comment and publish a final rule, it's very likely they can do that like by the end of the year if they want to. So that's going to be before January next year. So we'll see. We'll see what the final rule looks like.
Yeah, thank you. Where can we comment during the public comment period?
Oh, there's a link. Maybe I can share, or maybe Go Elite can share that link with everybody. Let me see if I can maybe find this link and share to the chat.
Sure. And I think we already been sending emails to students with those informations.
Okay, that's great.
Yeah, and then we will for sure share another one after the webinar and to everyone who attended today. If you wanted to drop in that comment, feel free to. We will jump into the next one. I think we have 2 more minutes. Does this reason rule affect you? Okay, this one, sorry, answered. For the wage-based H-1B rule, will the wage considered be just the base or base plus stock plus bonus and etc.?
I see. Well, whichever amount your employer put into the form. So I believe that is the base wage, and that's what they would use.
Got it. What does at the time of filing the petition means for the fee when registering for the lottery or after someone was selected?
After when we say at the time of petition filing, that is after the selection when we file the full package.
Got it. Thank you for that. In a situation where the F1 visa expired, but I-20 is still valid for 1 more year, will this new rule affect the process of visa renewal if happens by December 2025?
I would say I'm not too sure what this looks like. So, does that mean the person had an H-1B visa before, which is now?
We're F. I think the student is still on F1, but then a visa already expired, and
Mhm.
this person hold a valid I-20, so she or he still stays here. And then the I-20 will be valid for 1 more year. And if she
Okay.
wants to renew that F1 visa, what
F1 visa.
um I I am not sure this person actually didn't really clarify this part. I guess if yeah.
Okay. I just assume, if you're asking about this proclamation, as long as you had H-1B before, okay, you're not gonna be required, your employer is not gonna be required to pay the 100K. So as long as you had H-1B before, the petition with USCIS would be fine. They don't have to pay the 100K.
Mm. What if the student never had H-1B before?
Well, if they never had H-1B before, they have been in the US since September the 19th, the petition is also okay. So the proclamation would really target those who were outside the US and who never had H-1B before, and then the employer is filing the H-1B for them for the first time.
Okay. All right. So it is time. Like I said, if your question wasn't getting answered, feel free to reach out to us later on. I'm so sorry, but it seems like we still get a lot. Well, thank you so much for all you guys' time and joining today's webinar. And thank you so much for giving that thoroughly explanation. Thank you. And that will be all for us today.
Thank you.
Bye.
Thank you very much. Thank you for having me. Thank you, everyone. Bye.